All right. Well, welcome everyone to Data Discourse, practical advice and insights about digital forensics and e-discovery. We're here at season 2, episode 5, which is titled Digital Evidence Update, What's New in Computer Forensics. As you can imagine, the world of computer forensics changes very quickly. New devices, new computers, new applications, new methodologies for securing data encryption, all of the above. Really makes this a space that what you learned yesterday may be different than what you learned today. So we thought this would be a good spot to provide some updates and talk a little bit about what's changed and what's the status of computer forensics today. So to that end, our guest is Jeff Stiegler, Director of Computer Forensics at Precise Discovery. If you didn't know him, I'm Pete Mansmann, CEO. And Jeff, welcome back to Data Discourse.
Thank you for having me, Pete.
So, I know you've been on prior episodes and introduced yourself before, but given that maybe this would be a sort of reacquaintance of sorts for some folks who haven't listened in a while, could you talk a little bit about what you do on a day-to-day basis, kind of what your role is at Precise as a Director of Computer Forensics?
Yeah, so I'm getting requests from law firms, companies, sometimes individuals. It's simple as, hey, pull something off my phone related to a lawsuit, or maybe not related to a lawsuit. Or, hey, I'm trying to recover some deleted data, or, hey, my company is involved in a, massive lawsuit with another company. We have multiple, mailboxes to collect, multiple file shares to collect, just a ton of evidence to go through. We need help both collecting that properly, analyzing it, reviewing it, and then producing it to the other side.
So generally involved in litigation, I think it's fair to say, but maybe can you tell our audience, briefly describe what you're seeing most often right now in terms of computer forensics and mobile forensics? Like what kind of requests are you getting more often than not, in let's say the last 6 months or a year?
Yeah, I mean, the types of requests aren't necessarily changing. It's still your typical automobile accident. Was a cell phone involved in a distraction event or otherwise? Help me determine location of someone. What did they do throughout the day? Departed employee. Were they taking data? Were they communicating with former clients? So the types of engagements and requests aren't changing, but what is changing vastly is how we're able to collect some of this data, and then also how much of that data is actually available to anyone in this day and age, and then what we're able to do to decipher, report, and make opinions on all of that data.
And so if we were to talk a little bit about, let's say a lawyer has worked with you 2 years ago and they come back to say, hey, Jeff, we had a good experience in that case. We have another matter for you. Can you talk about some of the things that you typically have to temper discussions with, or maybe it's someone 5 years ago or whatever it might be, the length of time that you have to say, hey, I just need to make you aware at the offset. These are some things to be aware of that I'm seeing now pretty regularly that, may change what I can do, how we work together, things along those lines.
I think the timeline on that is, sometimes down to weeks. If depending on what you're talking about, days. What I could do today, I can't do necessarily 2 days ago because of a recent update. How a service behaved 3 years ago, how long they retained data, how much of that data was accessible. More than likely or not, apps are constantly updating, services are constantly updating. And a lot of these updates are at least presented with user privacy, data privacy, security in mind, almost to the extent they can be considered anti-forensics in some circumstances. So that's what you're kind of seeing, an involvement into, data being harder to obtain, it being in places you would have never thought it would have existed, previously. So, every case now kind of has to be treated like, forget what you learned in the previous one, because it may not work.
So I guess it would be fair to say, it's a reset in a lot of ways that, what might have been true a while ago could not be true today, or may still be true, but you can't go in assuming what a methodology you used in the past is going to be the automatic way to tackle something today.
Absolutely, and then the more time that goes by, I mean, like I said, the time frame on these changes is now weeks and months, and it's constantly, and we're always trying to catch up to, you know, how does this app behaving these days?
And when you're
Because
when
we
you're
have
saying change, yeah, when you're saying changes in weeks to month, you're talking about changes to devices or security features on devices or applications, just everything that people are touching and using, whether it's hardware or software, is changing so quickly that, it really changes the way you may approach it. The same sort of requests from a year ago to today.
Yeah, everything from where the data is stored, how much of the data is stored, is the data even readable? I mean, you can now have fully encrypted applications, which are basically the data is unusable. All these things come into play and are constantly evolving.
Gotcha. So let's turn our attention to what we see almost involved in every single case today, which is phones. And I think we want to spend a little bit of time talking about phones and changes in phones, expectations with phones, because again, we've talked about this in the past, but I don't think it's a surprise to anybody listening that everybody's got their phone glued to them pretty much while they're awake, and because that's the case, almost every matter we get involved with, a phone is a highly potentially relevant source of information. So keeping that in mind, from a litigation standpoint, how much harder have mobile phones become to extract compared to even a few years ago?
The vocabulary is very important. I've for years have always steered people away from using imaging on a phone, because you're never going to get the classic every copy of every bit and byte from a phone, just because of the way they're constructed. A really good way I heard it described recently, which I've been using, is we're not necessarily breaking into phones as examiners, but we're negotiating with it. We're getting as much data as it's letting us get in. These devices are constantly being updated by the manufacturer, again, to the extent of data privacy, data security, but in reality, they're more or less anti-forensics. They're segregating entire areas of storage that you can't get access to using the same traditional methods you could previously.
And when you say anti-forensics, it's not like Apple is saying, well, I don't want Jeff Stiegler to access this phone, but I'm guessing, and correct me if I'm wrong, that some of the methodologies that you're using to examine a phone are the types of things that Apple is trying to prevent a bad actor from doing, whether it's a phone that was lost or stolen and they're trying to access it in some way, or somebody's trying to break into a phone, remotely, whatever it might be. That same protection that they're applying to the consumer for a potential bad actor are the things that's making it more difficult for you to do your job.
Yes, there are logical reasons behind some of these features. One specifically, Apple a couple years ago implemented stolen device protection, which essentially can not only detect if your phone's been physically abducted from your, it detects sudden movements, vertical, it can tell if you've been pickpocketed, but also implements things like, okay, well, I was sitting next to this person, I watched them enter a passcode, I now know their passcode, I can physically steal their device and do whatever I want with it. Stolen device protection will actually implement some, emergency security features. The passcode no longer works. It requires your face or your fingerprint. It completely locks down the phone. It might reset the phone. You can have, you can set up emergency, I want to hit the top and bottom volume button at the same time. And it's going to put my phone to a state where it's more or less locked down, unless myself, even anyone that knows my passcode can't get in it. Biometric authentication is kind of being added as another layer. Think of your traditional multi-factor, email authentication. I need to log in and supply a text code. A lot of these devices now, the passcode also requires some level of biometric access and authorization.
So I know we run across this, but sometimes what's being asked to be examined is a deceased individual's phone, car accident or otherwise, that we're trying to take a look at what happened on the phone, and obviously they're no longer with us. If these biometric features are a sort of secondary piece to some of the protections in here. What does that do to the equation when you have someone who's deceased?
So I've gotten, a couple requests. Well, we could go down to the morgue and pull the body, but there's actually features built in, and there have been for a while now, where Apple can detect that your eyes aren't moving at all. The fingerprint requires body heat. It can detect humidity. It would be very hard to fake a biometric scan at that point. It's aside from the ethics of it.
Right.
The expectation that everyone has access to a deceased individual's data, what's the point in, having security on any of your data at that point? So that scenario really, it's safe for movies and TV shows, I think.
So when you do come into that scenario, what are your options?
You can set up now, unfortunately, they're kind of ahead of time things. You can set up a legacy contact in Apple. But Apple or Google or whoever, like, they don't know anyone's passcode. They can never provide the passcode for a device. They could maybe provide access, with legal authority to an iCloud account that might have, some of, like, a lot of the account information, images, maybe some videos and content and things like that. But as far as, say if you're trying to determine if a deceased individual's device was used in an automobile accident, you wouldn't necessarily get device-facing data. It would be account related only. And I don't know of any way around that. Certainly as a civilian, maybe law enforcement can get a little more leeway, but there is some expectation of privacy for deceased individuals.
Gotcha. And I would assume, sort of on top of that, so we have these biometric features, whether it's face recognition or thumbprint or whatever. Kind of gone are the days where you could just plug into an iPhone and extract data through a cable connection. I'm assuming that these biometric features are still overriding any kind of physical connection.
So without giving away some, proprietary software things I'm not allowed to talk about, we have ways of negotiating around those. Unfortunately, it takes the software, the forensic software, some time to catch up to the devices or the operating systems. But we can get data. It's more a question of, is it going to be, a traditional method, in and out, no sweat, or, do we need to look into some alternative methods because of some of the security functions in place?
And so everything you just described, whether, hey, we got to use some alternative methods to try to gain access, or we need biometric permissions to get into a device. What does this all mean practically for attorneys? Is it more time, more cost, or sometimes we just can't get it?
So most of our engagements are, on the side of, either being court ordered or, in mutual agreement that, hey, I need to show up and provide my data. So, to that extent, it's a matter of, maybe ahead of time determining, what kind of device we're dealing with and how much interaction we need with the individual. There may be a circumstance where, okay, well, I don't care if you have the passcode to that phone or if you have even some internal, device management you're running on it. There may be an instance where we need to court order the former custodian to show up and provide a fingerprint or an additional method of authentication. It can happen. It shouldn't be expected on every matter, but there are periods of time where, in circumstances where that's the case.
So it would be fair to say then that you can't assume you can do everything you need to do without any user of the owner of the device intervention. Sometimes that's going to be required to get to where you need to get.
Yeah, it used to be as simple as, okay, drop off your phone, give me a Post-it note with your passcode on it. Now it's, okay, why don't you come in and sit down? Let's, make sure we can get the things moving that we need to, because I may need your interaction, and obviously you're not going to have your phone with you. So, and again, it's always better it's preference to have some time with the custodian. But sometimes that's not possible, and you have to make do with some of the maybe alternative methods of imaging, which maybe not be as comprehensive, but work at the time while we're waiting for a more formal method of extraction to be available.
Gotcha. So another area I wanted to talk to you about is secured or locked folders. And secure folders, they sound like something consumers use for privacy, but what do they mean practically in terms of discovery or investigations from your standpoint?
So, in addition to these devices just being incredibly encrypted, and then having the majority of the application data behind another layer of encryption, and now you're adding functions like the secure folders, secure notes in Apple, which is maybe a third layer of, even at the point of extraction, an examiner might get a dialogue of, hey, we've come across, if you can provide the password now, we can extract it, but if not, we can't even pull it from the device. Or if we can pull it, we can't make any sense of it without this additional authentication. A lot of times these folders are set up biometrically, let me in with my fingerprint, not an additional passcode. And then I've not encountered this personally, but I've heard of issues in extremely contentious cases where it's specifically itemized what the other side has access to. An instance where, okay, we provided you authentication information for the device for the iCloud account. You didn't specify you wanted the notes password for this secure notes area, so we're not going to provide it. I don't know how well that argument worked. I'm sure it was provided eventually, but it's kind of important now to know that these additional layers can exist, and because of their very function, they kind of look suspicious. I'm going out of my way to keep this off of someone that might have base access to my phone. So you're always kind of interested in what might go on if they're in this.
And so if we're to describe how this is happening on an end user basis to our listeners out there, this would be a situation where, all right, someone has their phone, they're now in their phone, they want to create a note in their phone, but they can add an additional requirement to have a passcode or some other biometric requirement to open the note, even though the phone is open and active, something along those lines. Is that a good description?
Yeah, that's about exactly the case. Fortunately, most common users don't even know this is a function. Unfortunately, the ones that do know are maybe the ones on the technically savvy side that might be more aware of it and might want to take advantage of it. You don't see it too often yet. I'm sure there's going to start being some default data pushed to these personal folders. I'm sure at some point your phone's going to be able to identify, hey, family photo, throw these in a special secure private folder, without the user even any interaction. So these are things that let's keep an eye on, because I think it's going to become more of a problem in the future.
And so sort of like summarizing what we just talked about. So because we know, hey, just providing a passcode alone, on the post-it note and saying, go collect the phone doesn't work anymore. And you're most likely going to need these additional layers of security. And then we might even get into folders or notes or whatever it might be that also have a layer of security. What should attorneys be doing early in a case to avoid problems of accessing data they may ultimately need?
I mean, to some extent, I would say, identify these sources, but there's so many these days, and they're so convoluted and constantly changing. I would say, reach out to an expert first and help you identify sources. I mean, people are using services they don't even have an awareness of these days. All of your documents exist in a OneDrive account, although you may have no idea what OneDrive is. It was set up for you. It just happens to be where things are stored. So it really takes a lot of interpretation, following the trail of breadcrumbs. I know I keep files somewhere. Okay, well, show me. Show me what service you're using. Okay, let's make sure we're getting that account in addition to whatever data might be native on a local device.
Got it. So earlier better to have discussions and understand what potentially is in front of you before you just dive right into it.
It's better, but you're always going to find out the most by actual performing an examination. Oh, we do have data in this service we doesn't necessarily didn't consider in the initial review or interview. So it's kind of a step-by-step process of identification. What you identify at the beginning of the case is, in most cases, is not what you're working with by the end of it.
So let's turn our attention now to a different subject area: auto lock, BFUs, and device states. So first of all, what does BFU stand for?
So these refer to phone states. BFU is before first unlock. The kind of step beyond that would be AFU, after first unlock. Working backwards, the third step is a fully unlocked phone. All the authentications in there, the encryption's basically open. We can communicate with it, and this is more relevant to law enforcement. Seized devices. I mean, there's very few scenarios where an expert in my field and working in e-discovery / civilian forensics is working with oh, we need to crack the passcode on this device. So these states don't matter as much, but they're still kind of important to understand that the phones are designed to behave differently and interact with other devices differently based on the state they're in. A phone that has been recently unlocked and kind of active is going to relinquish much more data than a phone that had been shut off in a drawer for 6 months and is now you're opening up in a before first unlock state. Like I said, though, typically we're getting those unlocks, but there may be some scenarios where wherever the engagement is, that the phone state really matters as far as how much data you can get from a device.
And so you mentioned about the scenario where someone's saying, oh, well, we powered that phone down and preserved it, threw it in a drawer until we could get to a point to engage a forensics person or figure out where this lawsuit's going. Are there problems with doing that? Is that still a good methodology for preserving phones, or are there considerations to take into play?
I think it's not a common scenario where the timeline is that condensed for a non-law enforcement engagement, but I would say it's still probably best practice to store a device in an offline state. More often than not, it's going to cause much less harm and hassle than being online. I mean, I actually have some attorneys now that have their own Faraday bags and are shipping their devices to me in Faraday bags, which is kind of wild how far we've gone. That they're aware of the potential for data to be overwritten or whatnot remotely. So it's kind of interesting, with regards to that whole aspect.
And the concern, I would assume, is that, hey, let's say you have a phone, you have it set aside, you didn't turn it off, you have it plugged in, so it's just sitting there. Unless it's powered down and it still has an internet connection or a Wi-Fi or a cell connection, it could still be getting updates and changing things on the background automatically that you may not even be aware of. And the phone that you might get weeks later and look at could be very different than the phone that was set down on that table and plugged in for the first time.
It's definitely happened. And we're not talking weeks. I mean, a phone being stored in a drawer, but still connected to a charger for a year, which is now still getting synced iCloud account information because a personal iCloud was used on a work device. And I mean, it just caused a scenario that could have been just avoided by having the device, stored away properly. I always tell people, turn it off and put it away somewhere till we can figure out if you want to do something with it and what we can do with it.
And I would assume in some of those scenarios, it gets difficult to explain to somebody that, no, this isn't a user interacting with this device, and they're seeing activity and saying, well, you told us you didn't have anything to do with this, and activity showing up on the phone and showing up on a sync cloud account. And, it has to be explained and laid out that no, this is automatic syncing. This is sort of self-running things in the background. It wasn't a person doing this.
That has come up, specifically in cases, where we're trying to determine if someone was in a specific location or not in a specific location, related to this specific matter. Someone was on vacation. We were trying to prove they were in fact, not even in the same state an incident occurred at the time, but because they were, actively web browsing or using apps on their phone, they were still getting targeted ad information for their home location. These ads happen to even contain some addresses or GPS data, which do show up in forensic software as potential location data. If you look at it hard enough, you can usually discern that this wasn't necessarily a user visit or Google Maps. How do I get to this place? But some sort of background process that just happened to unfortunately throw this location into my timeline. You're seeing it on computers too. The horrific Windows is constantly loading little ads and little widgets and all this information all over your screen, even when you're not sitting there. Therefore, it just inherently looks like a computer is visiting websites and loading URLs and downloading images and doing all these things when no one's in fact sitting in front of it doing anything.
So unless you have the technical expertise to understand what's going on, you can very easily misinterpret some of those reports and the data it's reporting as being something very different than what is happening in actuality.
For sure, an internal IT support may look at some web history or pull up some artifacts and say, oh, this computer was used for 6 weeks after they were terminated, and they shouldn't have been doing that. When I've gone in and determined it just happened to be plugged in and connected. No one was actively logged in, opening anything, but the computer was doing things in the background. And yeah, technically the computer was being used, but not by an individual. So that's a scenario that's come up.
Yeah. So let's talk a little bit about OS updates and lockout periods. I know, we were just discussing it this morning that here it is, February 12th of 2026. And just today there was another Apple update that is causing some issues. So can we talk about that, and what does update mean? And practically speaking, how does that impact you as a forensic examiner?
So it goes back to we're negotiating with these devices. We're not breaking into them. Every decently sized, major operating system update, which, the latest occurred yesterday, iOS 20. I can't even keep track of what they're on now. But what that means is we need to let our software catch up to this negotiation. How is this device behaving now? Sometimes it's not consequential at all. There's no big deal. Sometimes we can basically not have access to the device in the traditional method we would normally use until we get an update from the software side. These blackout periods could be 24 hours. Could be 2 or 3 weeks, typically not longer than that. In those scenarios, you kind of have to just communicate with the client and tell them, eventually we'll be able to get everything out of this. If you really need something now, there are other, we're not fully locked out of these devices. Now you're looking at what's called logical extractions, which probably contain less, for sure, inherently contain less deleted data, less application data. You wouldn't be able to pull any email from the device. So they'd be you have some options for limited extractions until we can get back in and do it fully the right way.
So when you run in that scenario, someone's just dropped off, let's say yesterday, someone dropped off a phone, and now we have this OS update that happens this morning. What are you typically telling a client is the best course if they don't need something tomorrow?
Yeah, every case is different depending on what if we're just waiting on access to pull some messages and authenticate. It's one thing. If we're trying to reconstruct the timeline of a industrial accident or automobile accident or something that granular, I would say, okay, that's definitely wait, and let's do this when we have full access. Otherwise, maybe in the meantime, we can get in and, produce some reports while we're waiting for that access. At the very least, there's always the traditional method of just, manually examining the phone and taking authenticated screenshots of data you might need immediately while you're waiting for this to kind of unfurl.
So depending on the needs and the timeliness of the client's that particular case, might be something that you can do some things right away. It might be something where you tell them to wait a couple weeks when the OS is, the software is caught up to the operating system changes, and you can go in and get everything you need off the phone.
Yeah, and I mean, you also have to be aware that not everyone is updating their phones as they should. Although these days the process is mostly automated, but I mean, there's still requests involving devices that can't even get the newest updates, and we have no problem getting into it anytime. So that's still very much a thing too.
Gotcha. All right. So I think, Jeff, it's still fairly common for us to get requests for recovery of deleted information off devices. I know that's, comes in pretty regularly through, people that I talk to, and I'm sure that passes down to you as well. Can you talk about how realistic is it to actually get deleted information off devices today?
I wouldn't say it's not realistic, but it is extremely difficult, and the time frame you have to get access to this data before it's truly gone is, I mean, we're talking in some services seconds or minutes, as opposed to historically it could have been weeks, months, or years. These systems are designed to treat deleted data completely differently, down to the hardware level. Even hard drives these days are inherently physically different than the old classic hard drives, and with that comes different ways of how they manage when can I overwrite deleted data, what am I going to do with empty space, and then you bring encryption into the mix, and we're getting into file-based encryption, which is extremely common, especially on mobile phones, where you would traditionally think of an entire hard drive or an entire device being encrypted with one key to unlock that and make it readable. And some of these devices now are being designed where every single file, not only every database, but maybe every entry in a database might have its own unique encryption key. What this means in terms of deletion is when you tell a device or a service to delete some data, it's in addition to potentially just deleting the actual content of the data, maybe that email or that message you want to delete, it's also deleting the encryption key with it. So even if in the off chance you get access to that area where the deleted data existed, you can't make any sense of it because you no longer have the unique encryption key for that file or entry. Without that, data is essentially, unusable.
And I guess expanding upon what you just talked about with encryption keys, there's a term that's out there. It's called block rekeying. And can you explain what that is and why that matters to this topic?
So that's even another layer of encryption where every time a file is modified or even accessed in a certain system, it may be re-encrypted. There used to be some methods in specific scenarios where if you knew the encryption key for some files on a device or drive, you could use it to extract the other encryption keys you needed, or vice versa. What this does is basically makes any of those processes just not even able to be performed logically. If your keys are constantly changing, you're never going to be able to use any historical encryption key you come across to unlock the new file.
And just because it's in the news right now, Nancy Guthrie, she's Savannah Guthrie's mom, who got kidnapped from her home in Arizona. And as of today, they haven't found her, haven't identified her kidnapper. But one of the big things that they had as a breakthrough was she had a Ring camera, and they knew that there was an alert to the Ring camera that said, hey, it detected motion, but they weren't sure what motion it detected, what it saw, or anything, because she didn't have a subscription to Ring camera, which meant that she was essentially using it as a pass-through camera to be able to look on her phone, anytime someone rang the door to see who was there. But it wasn't like recording data that you could go back and look at years later. Well, it turns out that in this particular situation, the kidnapper goes to the Ring camera, gets recorded for the 10 seconds or so at that point, and then rips the Ring camera off and disables it. Because the Ring camera could not overwrite itself, it preserved that footage that they were able to recover off the servers from Ring, because they were like, it's only keeping, a few seconds of data before it's automatically overwritten by whatever else is recorded, just as a sort of pass through. So even though she didn't have this subscription, they were able to pull that footage off of the Ring servers and be able to look at that. So it goes against the initial idea of, oh, well, you can't recover deleted data. Look, they got it off this, but it wasn't deleted data, and it would have been overwritten if that camera would have stayed on for a few more seconds, or if that person had left the camera on there and the next day the police are up there, that footage would have been gone. It would have been overridden. It was just happenstance the way that all worked. And I think it actually shows how this all works, that they just got super lucky in that case, that him destroying that device prevented the overwrite.
Yeah, I've not heard any of that. That's kind of, I was aware of the Ring footage, but I wasn't aware of the circumstances that it was, I guess locally extracted then. Of course, they've been in, the topic of conversation lately because of the Super Bowl ad related to, hey, we can potentially use your Ring camera to identify missing pets throughout the neighborhood, which is, awesome if you're a dog lover, but not awesome if you're a privacy and security lover. It's going to be interesting to see how these services are maybe starting to be open about, some of the data that they're collecting. So what is Alexa actually listening to? We'll see that play out.
Yeah, and I think it goes to prove that was a case. Again, I think they got lucky, but you don't give up, and you gotta be creative in how you think about things to see, have you crossed everything off your list? Because the initial reaction was, I remember watching this on the news, that the police were like, this is a dead end. She didn't have the subscription, so there's nothing here to be captured. And somebody was willing to dig in it a little bit further and actually found this. So interesting stuff. Sad, but interesting. So let's move our attention now to storage, because storage has changed dramatically in the years we've been doing this, and wanted to talk a little bit about that. And we identified sort of SSDs and TRIM as two modern storages in particular to talk about. Can you explain a little bit what SSD and what TRIM storage is, and how this is very different than what people might traditionally think of as storage on electronic devices?
So if you understood what a hard drive was 10 years ago, you're probably thinking of platters that would spin, heads that would read, the awful noises it would make sometimes. The modern storage devices are essentially just chips. There's no moving parts. And in doing so, the design of just how these things function, store, write data has completely changed. Traditional platter drives would only overwrite data with specific instructions. They were dumb devices. These solid state drives now, they're designed to, as they write data to themselves, to load balance it across various areas of the chips, and in doing so, a solid state drive can't overwrite a block of data. It needs to delete it and then write the new data to it. So the idea of like data being overwritten, really, it doesn't even logically, mean what we meant years ago. These devices are also like constantly cleaning up without instruction. I've heard of scenarios where an examiner followed best practices and removed a hard drive from a device, connected it to a write blocker for a clean forensic extraction. And because that hard drive received power, it had internal functions built into it to, hey, perform cleanup functions. Trim is basically the hard drive reorganizing itself so it can last longer. In the simplest context matter, it doesn't have anything to do with encryption or data access. It's just so these things can only write a limited amount of time, so it tries to spread out where it's writing to. And in doing so, it's moving your data around constantly. So where your deleted file existed 5 minutes ago, it probably isn't where that it's allocated now. It just completely changed the game as far as being able to carve out files from deleted space. That deleted space, first of all, those files are probably encrypted. That unallocated space is probably encrypted itself, and now we don't even have that other layer that we need to make any sense of it.
So it sounds like these storage devices have gotten smarter, and they're sort of self house cleaning along the way, whether there's user activity or not. And they in those house cleaning activities, they're getting rid of what would have been deleted files that in the past we may have been able to access, absent the fact that most of these are encrypted anyway. And if you could get to them, you probably couldn't open them up anyway.
That's very much true.
Okay. All right. So just as a wrap up on the deleted data as it relates to encryption and storage and what's realistic or not, like, could you give a one sentence attorneys should use in court about why deleted data isn't recoverable, and what would it be?
I think just to the inherent nature of how this data is stored, there's no reasonable expectation that it can be recovered at any given time, let alone a considerable amount of time in the future. Sometimes it's better to, or it's definitely easier to prove that something was deleted, but even to that extent, that's not always possible these days. And sometimes in a case, it might only matter that an activity occurred. Doesn't matter what occurred in that activity. It may be enough to just show that a message took place, not what was in that message. I think the expectation should be lowered to that rather than we're going to get actual content back.
Basically assume that you're not going to recover deleted data, and if you do, it's probably fairly minimal.
Content is gone. If you're lucky, you'll be able to maybe show that it might have existed at one point.
Gotcha. So let's now turn our attention to app and cloud-based data. This is become very prevalent, that data is actually living in the cloud instead of on local devices. So how does this, from your experience, catch attorneys off guard?
So where I'm starting to see it most now is in corporate environments. Everyone is familiar with their My Documents folder on their computer. You've probably stored all your files in there since it was implemented, decades ago. Now that My Documents folder, chances are it either doesn't even exist on your computer and exists in, to some extent, a cloud service like OneDrive or ShareFile or any of those. Or what's more likely is that your local My Documents folder is now maybe a representation of what exists in that account in the cloud. Because it's a representation, it might always be a direct representation. The device can be set up to, hey, I have 10,000 files in OneDrive. I don't necessarily need all 10,000, so maybe just keep a copy of 1,000 of them on my computer. The rest of them will just be shortcuts. So when you go to perform, say, an image of a laptop or a computer, during analysis, you go to find that, oh, well, these files aren't actually on the computer. We also need to expand this to the cloud service, to get everything.
And that connection between the local computer and the cloud service is called syncing. And that syncing is whether data is moving from the local device to the cloud or vice versa. Can you talk just briefly about syncing between devices, how that can have an effect on computer forensics?
So take for, I'm just making up an example here. Someone's working on a document, their laptop's in airplane mode. While they're working on a Word file in their My Documents folder, which is actually a representation of their OneDrive account. When they land, at some point taking a forensic image of the laptop, the version of the Word file probably doesn't match the version of it, before the synchronization took place. A lot of times you get multiple copies of files between two sources, but it's always better to have two of the same thing than none of something you might miss. So now a classic request for a user's laptop probably also includes, hey, we want the direct, we want a copy of the mailbox as well. We want a copy of the OneDrive account or OneDrive data as well, or anything else you might use in your standard workflow. The laptop might not be, the laptop anymore. Data could be elsewhere.
And from your experience, do you find that one source, cloud versus local, typically ends up being more complete than the other?
You would anticipate the cloud version to be the most complete, but like I said, that depends on reliable connection or way of syncing between the device and a cloud account. It could also be used nefariously. I think a user could disable syncing and therefore be working on I'm working on this local copy. Everyone thinks I'm in the OneDrive. Haha, I'm changing things. So it's more things to look out for.
And given that there is more things to look out for, how early should attorneys be considering cloud preservation if they're in a spot where they're considering collecting data, period?
I mean, at the same time, they're considering a phone collection, an email collection, a computer. It doesn't matter. It's just as important, and more often than not, it exists, even if the user isn't aware of it.
So, Jeff, you had used the term anti-forensics, in a description of how some of these apps and devices now act. And again, I don't know that it's necessarily anti-forensics aimed at Jeff Stiegler, a forensics examiner, but it's the protections that make a forensics examination more difficult, just because it's protecting people from multiple bad actor scenarios. So, apps now bake in some of these anti-forensics features. So what does that look like in practice?
So I think traditionally, anti-forensics was, the usage of things like disk scrubbers or, secure file deletion or, anything a user would specifically do to prevent someone like myself from gaining access or being able to extract or make use of data. Now you're starting to see a lot of those same features, the secure file deletion, the overwriting of logs, the various things be built into these applications by default. It's just how the apps behave these days now. So to the extent it's anti-forensics, maybe without explicit intention, but it's still becoming a roadblock or in some circumstances for examiners.
Now, the flip side of that, though, is that I think there's sometimes surprise in the logs that some of these apps are producing that people don't typically think would expect to be there. Can you give some examples of that or talk about that a little bit, where you've seen that, where, hey, even though there might have been anti-forensics sort of targeted application or segments to the application, there were logs that ended up being critically valuable for the types of information you were looking for?
We do get surprised occasionally. How much data you're going to get from someone or a device, really depends on how are they interacting with it, because you normally need user interaction, user instruction to even generate log files that an examiner might use to tell a story. Some specific examples, your phone isn't necessarily going around and it might keep some Google Maps entries and searches and some GPS location data, but if you're running a specific application, to keep track of your family, just location, whatnot, services like Life 360 is one. If something like that is on a device, in some circumstances, we have almost minute to minute, if not even granular location recording going on. There's recently some of the newer Samsung phones come with a built-in app. The user never doesn't even know it exists, called Samsung Health. It has nothing to do with physical health like step tracking or heart rate, but actually device health. And this application is meant to monitor things like the battery, screen time, and various system logs that when you think about it might not have much value. But when an examiner goes to sit down, we're now able to see, in instances of maybe an automobile accident, that the screen was activated, which application made the screen turn on, how long was the screen on. So, some of these circumstances are now actually, giving us more data than we would traditionally see, but, it's still very much variable based. Don't expect this device to behave the same as the next one.
And I would assume sometimes it's not till you get in there and look and see what apps are installed and used on a device do you even know that, hey, we might have a different source for some of the data that's actually of interest.
Yeah, or going back and, oh wow, that my software is now able to decode information from this app when we couldn't do it 6 months ago. Let's reprocess it and see, what we can make sense of the new data.
And I think you've said before in the past that context survives content. Can you explain that a little bit more and tell us what you mean when you say context survives content?
I think in the last recently, I brought up the fact that it's usually easier to maybe prove that something was deleted rather than get the actual deleted content back itself. I think using log files, and you can look at the messaging database on a phone and not see a device, or on a device and not see a particular message. You could look at some other log files on the same device and see that, oh, okay, a message did take place. We don't have the content. We can see what number it was sent to, the time it occurred. Maybe that's useful for the case. Or maybe there's a break in where we expected messages to be based on recently sent contacts, whatever, using one database, and it doesn't match what the actual database holds. In that case, you can help use that to prove that maybe data was purposefully deleted, things like that.
And we touched on this briefly about browsing history, in particular as it relates to ad-driven artifacts, but what about browsing history in general? Are you seeing a more of a trend towards private or incognito browsing sessions, and how has that affected your ability to see what somebody was looking for on the internet?
So, like, in general, I mean, this is something that has changed too. I mean, these old browsers were just keeping history indefinitely, years going back to however far it can. Now, by default, these programs are limiting their own history to a period of 30, 60, 90 days. So there's an inherent block on some access. Incognito browsing has changed a bit. It used to be we could prove that a site was visited, maybe not when, in an incognito browser. Now, most of that information is stored in live RAM, active memory, meaning if the computer gets turned off in time between the incident and the time of examination, which is a lot of times the case, that private browsing information may be gone. So it's gotten a little tighter, and I think people are also a bit more aware of that the function exists, and therefore might be using it more often.
So given that on the one end of the spectrum we have less browsing history data being kept historically, or it's in a temporary space that can go away very quickly. On the other hand, as you mentioned earlier in the podcast, you can have what looks like browser activity, but it really is being driven by ads. Could be the Internet Explorer or whatever version of a browser you're using that's trying to put experience type data in front of you. Is it more important today than maybe there ever was, that you need some guidance. The attorneys need some guidance in interpreting what internet browsing history is actually telling them when it's coming from a computer.
Any examiner that is doing the job properly is not only looking to prove that specific activities took place, but also that it was user driven. In some circumstances, user driven by a specific individual. That's always a question of, okay, something was done. We know someone did it. We don't know who did it. And you using a scenario like that, you expand your examination to other things that might identify a specific individual. 2 minutes before this activity took place, did they you log into a Facebook account that can be directly tied to their name? Were they checking their email in the midst of downloading company files? So it's not always the report isn't always John Smith took client's file. It's someone took client's file. John Smith is logged into his email at the time. John Smith is checking his social media at the time. So you use other artifacts to kind of support the fact that it's actually a user visiting a site, downloading an image, doing whatnot, rather than the computer just behaving on its own background processes.
So you report the technical facts, and the attorneys make the inference arguments from that.
I mean, we'll try to make as many, support that with as many technical facts as possible. I mean, there's identification data all over computers and devices when activity is actually occurring.
Yeah. All right, emails. Emails aren't just emails anymore, and by that I mean that you look at Microsoft 365 or the Google suite of products, which are probably the count for 95% of email systems that are out there anymore, in particular as it relates to businesses. There's a lot more to think about in collecting in these platforms. Can you talk about that a little bit, and what are the considerations that need to go in? And maybe use 365 as an example here. When someone's saying, I need to get emails out, what is it that you might sort of follow up with them question-wise to make sure that they understand what they're asking for?
So, I mean, if we're just going to stick with 365, it's now, or whatever they're calling it now, it's now a mailbox, a OneDrive account, a Teams account for messages, maybe some SharePoint sites, maybe some other services that you can use. The normal request is, we have a matter, we need to collect some email, and then when you sit down and within the first 5 sentences of the conversation, it's we also share files, or we also use XYZ. It's okay. So your environment, Pete Mansmann at precise-law.com. Though we may want the email, we're probably also going to want the Teams messages in it. We're probably also going to want the files in it. In most cases, sometimes it can be scoped down to email only. But it's rare that anyone only uses email these days when all these other services are available.
So maybe more broadly, it should be, well, wait a minute, the request probably is for communications, and what does that mean?
I try to, we're talking communications, and we're not necessarily just talking text messages. Let's think about, group chats, Teams chats, third-party applications, platforms you wouldn't expect people to communicate over, social media. They're all there. So I think a more, apt request is, we need communication data collected.
Are you seeing Google more often in a business context, even outside of personal accounts, showing up in organizations that Google is their main email provider? And does it offer similar things like you just described that 365 has?
Google Workspace is becoming, fairly more popular. I'd still say probably 1 in every 5 engagements might be, Workspace versus 365. And it's come a long way as far as adding some e-discovery functions into the admin panel, adding some additional auditing, things like that a forensic examiner might find useful. Microsoft, on the other hand, is just constantly rolling out new features, whether they're needed or not. Almost to the point where it's hard to keep track of what is available what we can do these days and what we actually trust it to do. The cloud, I think the cloud services extraction is still being figured out from a forensics standpoint. It's almost like there's too many options to go about collecting the same data, which can be a good thing, but it's more things to consider.
So, and when you're talking about some of these features that, again, using 365 as an example, they're built in sort of pre-filtering features and functionality that you may be able to do some of in 365 that traditionally you would have needed to do in some kind of platform outside of the email system.
I still believe it's best practice to over collect, over scope, and then rely on a specific forensics or e-discovery tool to do your searching. But what you're seeing now in, like in 365 and Google Workspace is some layer of additional filtering, searching, even being able to tie into some of these review platforms directly. It's becoming a matter of, learning it, and also, I think more importantly, trusting it. It's going to be tough for us to get off of these tools, Celebrate, Relativity, Axiom, that we've been using for years, that we trust, and now saying, okay, we're going to perform the step we normally did down the line. Now we're going to perform it, while we're collecting data. I think it's always going to be a tricky compromise made between making sure you get everything you need, but still being able to scope things down when the situation permits.
And I think we're all in agreement. We utilize those tools when possible. It's just you have to be careful what the limitations are and where it's appropriate or not. Last thing you want to do is go through a whole collection scenario processing and a production and find out that something on the front end was flawed in 365 that, taints everything that happened afterwards.
Yeah, whenever possible, we try to avoid, double dipping in the data. Do it right the first time. If anything, get more than you need, so you don't have to go back and revisit it.
Yeah. And so one last thing I want to talk about emails before we move on to our last and final topic: attachments. Attachments is traditionally meant, I'm attaching a PDF file, a Word file, an Excel file, whatever it might be, sending it on. Has the idea or the concept of an attachment changed a bit in the last few years in terms of what you're seeing nowadays?
The cloud services, specifically things like OneDrive, have thrown a wrench in it, because now an attachment may just be a link to a file in our cloud environment that we both have access to, and not contain anything about the file itself. So in that scenario, that's where the email collection isn't going to be sufficient. When you go to process that email or look at that email, you're just going to have a link that doesn't go anywhere, not the content you need. Now, if you do the proper identification, see that, okay, we do have a copy of this OneDrive file, it was shared on this file. Let's ignore the email. Well, mark it as being, it existed, but, the actual attachment data is not in the mailbox.
All right, so we're going to move on to our last topic here. Certainly couldn't have a podcast episode about computer forensics in 2026 and not talk about AI. We're in the infancy stages still of AI as it relates to e-discovery, computer forensics. How's this all going to lay out? So I think there's probably more questions than there are answers at this point. But can you talk a little bit about requests that you're seeing tied to AI, like validating images and videos and documents, and how can we tell that they're actually accurate and authentic or not? What are you seeing in the forensics world, and what are you aware of at this point about how those are being tackled?
I think, if anything, people are more scared of validating any data now, whether it might be AI related or not, just because they're aware of how easy it might be to fabricate an image, a document, or even a phone call, or voicemail at this point. Can be faked. So I think there's inherently a lot more, hey, does this document look real? Does this, is this electronic signature actually legitimate? Can you help us verify that, my client signed this document or ever saw this document. It's not specifically just AI. I mean, from a technical standpoint, there are some software utilities that can help you detect that, and obviously, you can put some eyes on it and come to logical conclusions on on some things, but it's going to be tricky. It's going to get harder for examiners to determine. It really comes down to having access to that source. Someone sends me a document. Do you think this was AI generated? I would have to say, let me look at the computer the document was generated on. You're more likely to find an answer in that scenario. And with regards to AI being used by examiners, I think it's going to be a very slow onboarding process, different than a little bit different than I think what you're seeing in e-discovery. I think it's mostly due to the trust level. Discovery is determining if something exists. Forensics gets down to what's the legitimacy of its existence, who made it, what was done with it. I think they're still going to want to rely on human input and opinion and analysis for that, just based on one hallucination in an AI prompt alone could if an examiner bases an opinion based on that, I mean, what value does that have? So I think we're kind of interested to see if there's any aspects where it can make our lives a little easier or make the data a little more manageable. But as far as forming opinions and writing reports and whatnot, it's not going to be utilized as much as you might see in some other fields right now.
I mean, I could see it having its place where it's like, hey, you got all this data. Let me help and organize it in buckets and say, you may want to look at this first, or this data seems to be similar. And just, it's like having a great assistant at your side saying, let me organize all this before you dive into it. There could have some value. It might get you to critical data quicker. You definitely, I don't think, can use it for an interpretive element, certainly not at this point. And I know there's a lot of talk right now about the video and images, and video is a big one. That's a real problem, that there are embedded pixels or embedded watermarks in these images and videos from at least the major AI providers that are saying, oh, well, that's the way you're going to be able to tell whether something's AI generated or not, because it'll have these watermarks embedded in it and you can't see it. So I'm assuming at some point there's probably going to be some methodologies and tools that are going to help to identify that quicker and factor and faster and say, hey, well, this has that watermark or doesn't have that watermark. And therefore, we, based upon that, we'll be able to say it's more or less likely AI. But, right around the corner, there's going to be some AI tool that's going to use to get rid of watermarks or do something else. And so,
and
I
then
think right now,
I mean, then they have an immediate argument of, oh, it doesn't have the AI watermark, therefore it's absolutely not AI. Meanwhile, you could have people with 7 fingers on each hand in the image.
Right. And I think one of the things that at least people are saying, hey, well, how do I know that the video that you're purporting to be true right now is accurate? At least what I've read or seen, and I'm curious to get your thoughts on this, is that one of the best ways to do it is to go back in older data sources and say, did it exist there? And especially if it's something where you're like, this was sitting, this is a video that was pulled out 2 or 3 years ago before AI generated videos were a thing, then that alone is a pretty strong piece of evidence to say it's more likely to be legitimate. I don't know if you've come across that or heard anything on it.
I mean, we'll as examiners, we'll have to grasp onto any potential artifact or bit of data we can to help prove it one way or another. Metadata is going to be a big storyteller, but look how easy metadata is manipulated. Someone using AI to generate something probably has some level of intent to maybe cover their tracks, and probably some sort of level of technical expertise. So, metadata can't always be relied upon just because it exists. Some people are shocked when I show them how easy it is to change the date of a file. even for a non-technical savvy person.
But I think there may even be just some practical non-metadata necessarily evidence that becomes valuable, such as, hey, that video is sitting on this laptop that hasn't been fired up in 3 years. That alone should tell you that this is a higher probability of being what we're purporting it to be. It's interesting. It's going to be real interesting to see where this all goes. But I think if it's critical enough to validate it, and clearly we're authentication, you can't do this for every single file you exchange. But I mean, if something's important enough, that may be one way of proving its validity is going back in history and showing how far back can you show it. We'll see on that one. It's evolving. It's like I said, we're at the infancy on all that. There are no 100%. This is the correct way to do things in that area yet. It's going to be a creative space for sure to live in for a while. So we've talked about a lot of stuff today. I know again, this is an area that changes so quickly that we thought it would be good to get this episode in to sort of give an update for folks, and we'll certainly do that again as more things become clear. But if we were to sort of leave one or two points for folks who have listened to this episode to take away with them, what do you think is the most important things for them to realize with computer forensics today?
I mean, I think there's a reason why we're doing an update episode already, because things have just have been changing. The momentum is there that they're going to be continuing to be changing. It's nice to get the word out there that, hey, here's what we can do, based on various variables and situations. Sometimes you got to be a little patient. We're negotiating with devices and accounts. We're not necessarily breaking into them. And to reach out and ask us, hey, can I still do what I did a year ago, or can I even do more? I think that's the most value out of this.
Basically, don't assume that what you knew before is still accurate. You need to be having communications up front to be realistic about how things stand today.
That's absolutely true.
Okay. Well, thank you, Jeff. Folks need to get in touch with us. They can visit us at our website, www.precise-law.com, or call us at 412-281-8699. We're always available to talk to you about your case and sort of give you some guidance on what might be the best route forward. So thank you again for your time today. We look forward to speaking to you again on a future Data Discourse episode.
Thanks, Pete. Thanks, everyone.